Today was day 10 in Karen Reed's retrial, so it's time to recap everything that happened in court today, as well as play some of the clips from the testimony that I found a little bit more interesting. So we started off today with Paul Gallagher. You will recall Paul Gallagher started on the stand yesterday and was in the middle of cross-examination before the day ended. So we picked up today, continuing with Alan Jackson's cross-examination. Now, you'll recall from yesterday that Paul Gallagher arrived at 34 Fairview after already John O'Keefe was transported to Good Samaritan Hospital, and he came and he was processing the scene a little bit. So he needed to figure out a way to remove some of the snow without ruining the scene. So what he did is that he got a leaf blower, and he was using the leaf blower to clear off some of the snow, and that is when he discovered a broken glass. So he bagged that for evidence, and he also found some blood. So he had no way of transporting the blood, and there was an emergency situation. So therefore, he went and he got Solo cups to put the blood in, and then he also put them in a Stop and Shop bag, which he testified he doesn't even know where that Stop and Shop bag came from. So that is how he transported the evidence. So you recall that all from yesterday's testimony. So today, there's really 2 points where I want to talk about and focus on the cross-examination for today. It wasn't extensive, but I think these are the 2 interesting points. Number one is the fact that across the street from 34 Fairview, not directly across, a little bit of an angle across, there was a deputy who lived there, deputy chief lived there, and he had a ring camera. It wasn't really a ring camera. He called it an Arlo camera, but similar purposes for this camera right outside his house, outside his front door. And it would look like it would catch any sort of activity across the street, which is where Karen Reed's vehicle would have been that night when it backed up into John O'Keefe. So it would have been very good and helpful for the Commonwealth to be able to get a video of exactly what happened. So he was asked about whether he went through the bother to go get that video camera footage. And the answer was no, he didn't, because he happens to know that he knows that deputy chief, and he knows that camera, and he knows that that camera does not even pick up anything across the street. It only picks up directly in front of the house on the walkway. So there's really even no point of him even trying to go and get that footage. It's not going to show anything. So therefore, he didn't even get that footage. He knows already it's going to be a waste of time. So that's what came out in today's cross-examination. But then we got onto the issue. Moved on to the issue of search warrants. Whether this Lieutenant Gallagher should have gotten a search warrant or applied for a search warrant, filled out an affidavit and asked the judge for a search warrant to be able to search 34 Fairview. So before I share my thoughts about that, let's hear from the witness himself about what he believes, whether there was probable cause to be able to get a search warrant on 34 Fairview. So there's a few clips we have to play here. So we'll start off with this clip, and then we'll move on to some of Hank Brennan's questioning, and eventually we'll get to the end of it.
You also didn't, subsequent to that, you didn't seek or receive a search warrant.
No, I did not.
Okay. You didn't believe that it was necessary, in your mind, it was necessary to seek a search warrant to search the interior of that house.
That's absolutely correct.
You were aware at the time that you did go into the house that Sergeant Lank had earlier reported at least the possibility that John O'Keefe may have gotten into a fight, correct?
I don't recall that. We went over options on how he could have come to where he was, and an altercation certainly was one of them.
Okay,
so an altercation was one of the possibilities how John O'Keefe could have ended up in the middle of the lawn. I mean, that's pretty reasonable conclusion or option, that maybe this person who is lying in front of the house got into an altercation in the house, right? I mean, I'm sure it happens all the time. So sure, that was one of the options, but let's continue listening to the rest.
So that's fair enough. So an altercation meaning was one of the, when you say altercation, that means a physical fight, correct?
Sure.
So that was a possibility in your mind.
Everything was a possibility at that time.
And at that time, you had the information that you found, or Mr. O'Keefe's body was found on the lawn of a residence where there was alcohol, drinking, a party of some sort, or a gathering of some sort, just hours earlier, correct?
That's correct, but the house had nothing to do with the incident.
At least to your mind.
That's correct, based on the evidence, yes, at that time.
And the evidence at that time was simply your communications with some, but not all, the occupants of the house, including Jennifer McCabe, correct?
That is correct, yes, sir.
Okay, so he's right away doubling down. There's no connection to John O'Keefe being in the front of the house, lying there, dying or dead, and the house. You know, just because there's a party there, just because there's alcohol being served, just because he is found, and it's possible that he was in an altercation in the house, but there's still not enough to connect him with the house to get a search warrant. So that's first part of his testimony. Let's move ahead a little bit to hear some more parts of this line of questioning. And this is actually, I think this is Hank Brennan now taking over.
May I?
Yes. as a lifelong law enforcement officer, have you obtained search warrants before?
Yes,
Have you obtained search warrants for homes?
yes, many times.
Is there a certain requirement before you obtain a search warrant for a home?
Yes, critical legal standards, yes.
And what is that?
Probable cause.
And for us, what does that mean, probable
So,
cause?
so probable cause is a reasonable belief that a crime has been committed or evidence of a crime can be found in a specific location.
Can you obtain a search warrant if you do not have a reasonable belief that evidence exists somewhere?
No, you cannot.
Is there a process in getting a search warrant? Can you just walk in home and say, I have a search warrant, or do you have to do something?
You have to write an affidavit in good faith, swearing before the court that all your information is accurate and truthful, and present the facts, circumstances, witness statements that would make you believe that there was a reason to violate your Fourth Amendment constitutional right.
When you walked into Fairview that morning with Sergeant Lang, did you have a search warrant?
No, I did not.
Did you have any reason to get a search warrant?
No reason at all.
So again, no reason at all to get a search warrant. And yeah, he did talk about the probable cause standard, which is a very, very, very low standard. As we all know, it's very easy to get probable cause, to charge somebody with a crime, and to get a search warrant. So it's a very low burden, but he's saying still it is a burden. There is a standard here, and you have to meet it. And if you don't meet it, then you just simply can't just walk in someone's house and just or sign an affidavit saying that you should be able to violate somebody's Fourth Amendment. After all, you know, the Fourth Amendment is a pretty important one, right? Okay, so let's move on a little bit more to the final questioning on this issue. And this is where Alan Jackson's asking him questions.
Circumstances to have the right to search Brian Albert's house. We had no reason, and there's been no reason since.
How about this?
First of all, did you hear that? There's been no reason since. Meaning even after, I mean, he's talking about when he arrived at 34 Fairview. So he's talking about the first few hours of the investigation. You know, he at that point he didn't. Okay, you know, there's definitely more of an argument at least to be made in the first few hours of the investigation when they're still trying to wrap their heads around stuff. But then to say, and even since then, as we sit here today, you haven't learned anything that would give you then probable cause to search the house. I mean, that's a bold statement. We'll talk about that a little bit more later. But let's first finish this line of questioning.
How about this? There's a dead guy on the lawn that looked like he potentially could have been in a physical altercation. How about that? Might that be of some concern to go inside the house and see if there was a struggle started in the house?
There's still no evidence to go into the house.
You're the guy that's out on the lawn with no coat on. You think the coat might be inside the house?
So you got a guy also in the middle of the winter, freezing cold, and he's got no coat on. And he's right outside someone else's house. So what about that? So that's another reason. There's another some evidence to help you reach the probable cause standard.
That be a reasonable assumption? Yes or no?
No.
You got a guy outside with no shoe on. You think the shoe might be inside the house?
So what about that? What about the shoe? There can be evidence of the shoe. The shoe can be part of the crime. That can be evidence part of the crime. What about that?
A reasonable assumption?
I never saw Mr. O'Keefe. I wasn't aware that he
Because you didn't
have
seek
shoes.
to find out the details. Other people knew every single.
Okay, so then he's getting into, so you didn't have to actually do an investigation. You should have done more of an investigation, and then you would have found out some more details about the case. So again, he's doubling down. There's really no reason at all, no probable cause at all to be able to search that house, and therefore that's why he didn't attempt to get a search warrant. And I think it's just very, very difficult to believe that. It's very difficult, I think, for the jury to be convinced of that when you have somebody dead or dying in front of somebody else's house, a very likely possibility is that he's in an altercation. He doesn't have a coat on. And he also, the evidence is going to show that he was invited to the house. So they found that out because they were talking to Jennifer McCabe. And Jennifer McCabe told them, probably most likely, that he was invited to the house, right? So you got someone who's invited to the house. He comes over and he's at the house. And now he's dead, or dying. So is that not enough probable cause to be able to search the house? So now what about the fact that, okay, well, Karen Reed was saying that maybe she hit him. And again, whether she actually said she hit him and to which police officer she said she hit him, that's not very clear at all because there's no police officer who put in any report that that's what she actually said. Eventually came out later from Seraph that she said something about this is all my fault and I did this. But the only other people that really heard her say these admissions of I hit him were the paramedics. Okay, so again, we're talking about that's sure that could be one option. It could be one option that Karen maybe hit him. But if you're trying to do a full investigation, it is also a possibility, a reasonable possibility that something happened in the house. Especially when you're just trying to investigate the case. So even with everything together, there should still be probable cause to be able to search the house. You have someone who's invited over to the house, somebody who's outside without a coat, somebody that's likely could have been in an altercation, and the only other evidence to go against that is a lady who was most likely drunk at the time, over the legal limit, and running around crazy beside herself, hysterical. So you're going to say, well, we should just completely 100% trust that other lady who's running around crazy outside, and just and not even bother with even trying to get a search warrant for the house. Now, the second part about this is to have the gall to say that even after everything that we've learned in this case, there would still be no probable cause to search the house. Well, so after all of the evidence, let's talk about Dr. Russell and looking at the arm, seeing the injuries to the arm, how the arm looked like it's consistent with a dog, and the owners of the house had a dog named Chloe. What about that? And the fact that now that you've learned also that there's accident reconstructionists, biomechanical experts who have said that this interaction with the car couldn't have happened, there's still no probable cause to go into the house. How else did this happen? So, yeah, I mean, I think that's a very, like I said, I think it's a bold statement. I know that Hank Brennan tried to come back to that. He tried to finish off the direct examination with that. His redirect after everything was to say, and have you learned anything since then that would allow you to then search the house? And he wanted to get a no out of him, and he said no. I think he said no. But that was what he's trying to say. And that already is, I think that's even more offensive to the jury. You know, it's one thing if it's the first day of the investigation, first couple hours, you know, okay, you're still trying to figure out what's going on. You don't want to just burst into someone's house. You know, okay, I can understand more of an argument there. You know, I can definitely understand more of an argument. But to say that to the jury, that even after everything that we learned in this case, you still don't have probable cause, I think that if I was Alan Jackson, I may revisit this in my closing argument and say how ridiculous they're being. They're so ridiculous that they're saying that even after everything that we've heard in this case, after all the expert testimony in this case, saying that this couldn't have been from a car, and more evidence that we know about him going into the house, or, you know, other evidence that would suggest that, and they're still doubling down and saying that there's no probable cause to go into the house. I think, again, you know, that could be brought out in a closing argument. Okay, so that's what happened with Gallagher. Let's move on to the next part of the trial. Was there's some more clips that were played from the docuseries that Karen Reed gave. One of them was the fact that John took her glass out of the car. So here you have her statement saying that he took her glass out of the car. Now you find this broken glass. Okay, so trying to show some consistency and corroboration there. And then also he played a clip of that Karen Reed thought that maybe the reason why she thought that maybe that she hit him is because he was found in the general area of where she let him out of the car. So I think he wanted that to come in to show that he was found in the general area of where she let him off. So, okay, that's what I think he was trying to bring out with that. So those were the clips. Now, he moved on to Robert Gilman. Robert Gilman is a meteorologist, and I think he was the witness today that I think that everybody liked. He was just a very sweet man that I think a lot of people enjoyed, and he was talking a lot about history and talking about weather and weather patterns, and you know, everyone's just kind of sitting there. It's a little bit boring testimony, but I think he's a very likable witness, I think. So it was just a little bit boring, and really it took a long time, I think, to get to the point. And remember, this is where Hank Brennan actually wanted him to be able to testify that the ground is hard as a rock. That he was not able to say today. So he was able to say about the accumulation of the snow and the visibility. So essentially, he wanted to say, he did say that this was the worst snowstorm that they ever had in Massachusetts in January. It was like 20. The amount of inches at the end of the day was 23.5 inches of snow accumulation on this day. But something that was interesting is that by 6 a.m. there was only 1.2. I'm sorry, 3. By 6 a.m. there's 3.9 inches of accumulation. So that's significant. You know, it's about 4 inches, a little bit less than 4 inches. So 3.9 inches by 6 a.m. But before that, that's where it gets a little bit more interesting. Before that, there wasn't that much snow accumulation. There was only about an inch. And that's something that was brought out by cross-examination. And it was Robert Alessi who did the cross-examination. He said that by 1 a.m., there was only 0.5 inches of snow accumulated on the ground. By 1:45, there was less than 8 inches. So that means anybody coming out of that house, obviously he wasn't covered by snow at that point. It was just 0.8 inches of snow by 1:45 a.m., which essentially by that time, everyone was really leaving or have left the house already. And by 3 a.m. it was 1 inch. Okay, and then also he wanted to bring out the fact that the visibility aspect of the weather. So if you can't see, let's say, for a mile ahead of you, you could still see 30 feet ahead of you, right? So that's something else that, or less you brought out, is that even if the visibility is very bad, you could still see in front of you, even when it's snowing. You can still see on the lawn. So again, that is going to be one of the strongest points about this case, which the defense can argue for reasonable doubt, is that no one saw John O'Keefe's body when they left that house. And it's just a little bit of a coating of snow on the ground. So on the one hand, it lights up what's going on outside. When it's pitch dark outside and there's no snow, it's much harder to see. But when there's snow outside, even in the middle of the night, you still see a lot better. And you got this 6'2" guy lying in the middle of the lawn, and all these people leaving the house and nobody saw him. So again, just showing that all the snow that was falling, it was only a problem later on at like 6 o'clock in the morning when there's already about 4 inches of snow on the ground. Okay, so that was essentially, it was a long time with the meteorologist, and but that's essentially what the points that came out. So also he wanted to say that it was freezing, the ground was freezing, so that, okay, he was able to bring that out, but he was not able to testify about how hard the ground was. Okay, so then moving on to Nicholas Garino. So Nicholas Garino, this is like, I think, the third or fourth time that he was called. He's doing him in piecemeals. And part of the reason was because there was this issue that the defense wanted to bring out the text messages in Sandra Birchmore's cases. The Sandra Birchmore case, which is a very extremely tragic case. But in that case, they wanted to bring out some actions or misactions, whatever you want to call it, by Nicholas Garino. So they wanted to talk about that. They wanted to talk about some of the text messages in that case. And Judge Cannoni ruled today, right before Nicholas Garino was called, that they're not allowed to talk about anything that's going on with Sandra Birchmore case. So once there was that ruling, so now he called Nicholas Garino to talk about the text messages, some of the text messages, and admit them into evidence, and then also talk about the voice messages. So let's play the voice messages, and these are the voicemails that Karen Reed left for John O'Keefe that night. And remember, she is most likely extremely drunk at this point. Very, very drunk, and sounds like she's very, very upset. So just keep that in mind when you hear the tone of these voice messages. And then again, according to her, she dropped him off at the house and he wasn't coming out. And now she's stuck, I guess, kind of taking care of his niece and nephew by herself. And this is why you start to hear some of the frustration in her voice. So let's get to the voicemails, and just, you got children in the room. Maybe you should remove the children because some of them are pretty explicit.
Kindly play the voicemail for 123708.
And I'm just going to slow it down so you can hear it because it's not that long, and I'm sure you want to hear. So that was at 12:37 a.m. So it was probably very, very drunk at that point, and she's already gone home. She's already, at this point, she's already at One Meadows. She's already, her phone is already connected to the Wi-Fi at John's house. So she already left, and she leaves that type of voicemail. So again, the prosecution is playing this to show how she was very, very upset with him, which can also, I guess, lead to motive why she would want to run him over with the car. On the other hand, you got to think for the defense is that why would anybody who just tried to kill their boyfriend leave a voicemail like that? Why in the world would she do that? But they're playing, he's playing all these voice messages. So that was at 12:37. Let's move on to the next voicemail, which is right here. There's some text messages that she sends to him, and then we get to the next voicemail.
John, I'm here with your fucking kids. Nobody knows what the fuck you are, you fucking pervert.
So no one knows where you are. I'm with your kids. No one knows where you are. I'm with your kids. And she calls him a pervert because she thinks that he's cheating on her. So this is at 12:59 a.m. Okay, let's move to the next voicemail. Again, some more text messages. Trying to scare him a little bit. I'm back in Mansfield. The kids are home alone. But then we get to the next voicemail. Here we go.
On voicemail number 5 is left with voice.
Ms. Gilman.
Yeah, it's 1 in the morning. I'm with your fucking niece and nephew. You fucking pervert. You're a fucking pervert.
So again, another voicemail where she thinks that he's with somebody else, and she's stuck watching over his niece and nephew. And then that will bring us to the next voicemail. And here we go.
Voicemail 6 is left with voice.
Ms. Gilman?
John, I'm going home. I cannot babysit your niece. I need to go home. You are fucking using me right now. You're fucking another girl. Kim's sleeping next to me. You're a fucking loser. Fuck yourself.
So there you go again. This is at 1:17 a.m. So all these voicemails are when she's extremely mad, but also probably extremely drunk. So this is what we're hearing, and she thinks that he's cheating on her, and she thinks that he's using her, and she's like this babysitter now that has to watch over his niece and nephew while he gets to go party and do what he wants on his own. So that's where she's getting upset about this whole situation, and she's pretending that she's going to leave, so he has to come home. Okay, so that is in terms of the voice messages, and there was no cross-examination. So that's it. There was no cross-examination, and then they played another clip. So he played the next clip, which was a clip where she said that he didn't look mortally wounded. And she was talking about how maybe I hit him in the knee, maybe I clipped him in the knee. And then she says that, I mean, when I looked at him, it didn't look like he was mortally wounded. So what the prosecution is obviously trying to show with that is that when did she see him, and when is she saying that he did not look mortally wounded? Well, according to the prosecution, it's right then, right at like 12:32 when she hit him, and then she didn't think that he looks mortally wounded. However, the defense, as we heard from Alan Jackson, she was talking about in the morning when she saw him. In the morning when she saw him and was brushing snow off his face, he looked fine. I mean, again, you know, he had a bump on top of his eye, and she didn't really see what was going on in the back of his head. That's really what killed him. But and the hypothermia. But she was just saying, look, when I saw him at 6 o'clock in the morning, he looked like he was lying there, you know. So he didn't look mortally wounded. Okay, so that's the dispute between the prosecution and the defense here. So then we got on to Charles Ray. Charles Ray was one of the officers who did a well visit. So after John O'Keefe was pronounced dead, and now they know that he has this niece and nephew that he's taking care of, and now there's no parents, no adult figure in the house, it would probably be a good idea. They didn't know about Karen Reed, I guess. So it would probably be a good idea to do a well checkup, or maybe Karen was still at the hospital. So they felt that it was time to be a good idea to do a well checkup. So they went to do this well checkup, and that is where they see this picture. Now, this is maybe a picture that you saw before, and you can be the judge about what that taillight looks like. And again, this is before, this is early in the morning there. So take a look at. This is before the police had it, right? Before the proctor got his hands on it. So this is before any police could have tampered with the taillight. So you can go ahead and take a look and see what this looks like. Okay, okay, here's the picture.
Does that appear to be a still photo from the video we just watched?
Yes.
And could I have Exhibit 11, please?
So there you go. There's the picture. I'm sure you've seen it before online. This is the picture of her Lexus before Proctor got his hands on it, before anybody got his hands on it. And you see on the right side over there, definitely looks like there is something going on there. It's cracked. It's missing. So there's definitely, again, and Karen Reed would admit, and the defense attorneys would admit, that it was at this point, it was definitely cracked and somewhat missing. You know, the question is what the extent of damages to her taillight. So that's the question for you. Is this just a cracked taillight, or is there some pieces missing? And you can definitely hear the argument why there's some pieces missing if you look at this picture. So again, the question is going to come down to how seriously was that taillight damaged? Is it just a piece or two that's missing? Or is it like it looked like when they took it to the Sally port and they took pictures of it much later? So that's going to be the question. So that is the next part of what happened. Then we moved on to Kevin O'Hara. Kevin O'Hara is a Massachusetts State Police. He was a lieutenant. He works as part of the CERT team. So he was asked to come and collect the evidence, or any possible evidence, that was at 34 Fairview. So he responded, and he had the times down pat here. He knew the times like backwards and forwards to the minute. So he said that at 2:32 p.m., and this is important, obviously, because part of the defense's arguments here, at least the arguments that we've been hearing already leading up to this, is that when Proctor got his hands on this Lexus, it's possible, or the suggestion is that he went and cracked that taillight a lot more and planted those pieces at 34 Fairview. And the question is, did he actually have the time to do that? Did he have the time to plant some of these pieces before the CERT team showed up? That's question number one. Question number two in this case is going to be, if there is some pieces that were located there, how come so many more pieces were located later? So maybe there was planting going on much later in the case. But the first question is that did Proctor actually even have enough time to plant anything there at all? So this is why the timeline here is going to be very important. And this is what Kevin O'Hara testifies to. 2:32 p.m. he got the request. 2:53 they sent out a message to see if anyone's available, and they started heading to Fairview at 4:13 p.m. 4:13 p.m. Now, the Lexus showed up at the Sallyport at 5:35 p.m. Okay, it was already at the Sallyport. I think that was the time, 5:35 p.m. So when did they show up at 34 Fairview? Well, they left to go to 34 Fairview at 4:13 p.m. And they arrived at 34 Fairview at 4:56 p.m. I mean, one guy actually showed up at 4:54 p.m., but Kevin O'Hara showed up at 4:56 p.m. So obviously there's going to be a problem if Kevin O'Hara is there. I mean, it's going to be a problem for the defense case, but if Kevin O'Hara is there at 4:56 p.m., well, he's there. Then how can Proctor just kind of sneak in there when he's not looking to plant some pieces of taillight? It's going to be very difficult for him to do that, right? So this is what Hank Brennan is trying to establish with this witness, that it's not possible that anybody planted any sort of evidence. And in fact, he said that the search started at 5:24 p.m. So 5:24 p.m., that would mean that the search started before Proctor even had a chance to do anything to the taillight and plant anything. Now, it is true that it brought out that they didn't find the first piece until 5:45 p.m. Okay, so you're right. Technically speaking, the first piece taillight wasn't found until 5:45, but they began the search at 5:24. So the question is, if you're going to believe Kevin O'Hara 100% and say, look, he's got no dog in this fight, he's not going to try to cover for Proctor or anything, and therefore he's just saying the truth, well, then there's going to be a problem to this whole theory that Proctor planted the taillight pieces there. Okay, so again, he started the search at 5:24 p.m., and he said that nobody entered the area from the time that they arrived till they started the search. So that's what he did testify to. Nobody was there. No other police officer was there. And they eventually found some pieces of taillight. Again, the first time that they found was 5:45 p.m. and again at 5:50 p.m. And they actually found a very clear piece of taillight. One of the clear pieces they found there. They also found a sneaker at the curb. So they located in total 6 or 7 pieces of taillight, and they located the sneaker. And a couple of the pieces of taillight, Hank Brennan wanted him to make sure that it was clear about, was that it was found at ground level, meaning it wasn't on top of the snow. If this was planted, then it could be it was on top of the snow. But here, if it was on the ground level, there's more of a reason that no, it was actually there from before or after, and then the snow fell on top of it. So a couple of pieces were found at ground level. And then he said eventually the media showed up and they started taking pictures. And as they were doing this search, they were only searching in the street. They could not search in the front yard of 34 Fairview. It was not possible. They couldn't really do a good search on it. So therefore, they just concentrated on the street because they didn't want plows coming and messing up the whole street. So at least let's do the street now, and then we'll come back later and finish up and do the yard. So that was their plan of the day, which is why they only searched the street, and it was only possible for them to search the street. And that's where they found these 6 to 7 pieces of taillight. So they did offer to return later to continue the search. I mean, the search team offered, we can come by later and search the grass when it's not in the middle of a blizzard. We'll be happy to do that, but nobody asked them to ever return. And on cross-examination, some of the things that Alan Jackson pointed out were the following. Number one, he said that when you arrived there was no barricade, there was no crime scene tape up, there was no police presence. It was completely an unsecured scene. So from whenever they removed John O'Keefe, whenever the Lieutenant Gallagher was gone, it was an unsecured scene. So technically speaking, anybody could have accessed it and done anything to it. Okay, so that's number one. Then he also said that Tully was the one who was directing them where to do the search. And Tully didn't really even see John O'Keefe there. So he didn't really know exactly where he was found. And Tully only got his information from somebody else who didn't know where he was. So this is all, again, kind of the argument of the blind leading the blind. But nevertheless, they still did a pretty good search from the driveway, around from the driveway started, or by the front door, opposite the front door, and going up towards the flagpole. So they did search that area, at least in the street. Now, he also pointed out that while they were doing the search, some police officers, some Canton police officers and some Massachusetts state police officers, state troopers, they actually showed up to the area. And he wasn't really sure what they were doing there. Again, this is Kevin O'Hara didn't know what what these other policemen were doing there, but they did show up. And he also tried to say that, look, you were looking down, you were focusing on yourself, you were focusing on the search. It could be that you weren't really paying attention to anything that was going on. I guess suggesting that it's possible that somebody maybe have planted some pieces of taillight while you weren't looking for it and while you were expecting it. Okay. And he also made a point of the fact that Brian Albert, and he didn't know his name, but he said that the person in the house, a person from 34 Fairview, came out of the house in a hoodie, in a sweatshirt, and he did come out for a little bit. Then eventually also he said, another part that I think was interesting that he pointed out was the fact that these pieces of taillight, these 6-7 pieces of taillight that he did find, they were all within a few inches of each other, maybe a foot. That's where he found all these 6-7 pieces of taillight. And what was interesting was that these other 40 pieces of taillight that they're eventually going to find were all over the place. They weren't just within a foot of each other. So the question that you have to ask yourself is, how did this happen? I mean, like, how is it that these 6 and 7 pieces were right here, all within a foot of each other, and then the other 40 pieces were scattered amongst the front lawn? And again, there's not such great pictures to be able to see where all the pieces were at the same time, to be able to get a global look at it. So I think that's going to be one of the questions in this case, is that if this happened and this taillight just exploded, so how does it end up that 6-7 pieces are all contained within the same 6 inches, and then the other 40 pieces are strewn upon across the lawn all over the place? So I think that's also one of the points that he's bringing out. And again, it just throws another question into this case: is how exactly did all this happen? So maybe the accident reconstructionist, Brian Welcher, for the Commonwealth, will explain all this. That's possible. But we'll have to wait and see to see if there's any sort of explanation that's given about how this can actually occur this way. So that's going to be it for today. That was the extent of day 10. And then we're going to move on tomorrow with more witnesses for day 11. So you can definitely join us tomorrow for the live, starting at 9 a.m. of the trial. So join us live, and we'll see what witnesses are going to be called tomorrow. Maybe we'll get to an expert witness, maybe get to Brian Welcher, who knows. And that's going to be it for now. So if you haven't yet, please subscribe, like, and we will see you next time.